Well, Arise News analyst Frank Tietie and our judiciary editor Tobi Soniyi, both lawyers, join us on the news tonight to dissect this judgment, really. Thank you, gentlemen, for being on the news tonight. Let me begin with you, Frank Tietie. Any surprises here? This was a law, Section 84, subsection 12 was signed, the Electoral Act itself was signed, I think, on the 25th of February, and today is 24th of June. It's less than 4 months. Were you surprised at the ruling?
Oh, certainly not. The Supreme Court that was a fairly easy one for the Supreme Court.
Mm-hmm.
Supreme Court was wondering why the president was asking it to do the job that the National Assembly refused to do. And even though I haven't read the full judgment, but according to the reports that have brought snippets of the judgment, it was quite easy for the Supreme Court to decide, considering that it didn't even go into the propriety of the arguments that the President and the Attorney General brought forward, but to consider that, was it that the President was bringing the matter to the court simply because the members of the National Assembly disobeyed his instruction to delete a particular section? The Supreme Court actually dealt with the fact that he didn't have jurisdiction, and for a time-tested provision of the law with regards to approbation and reprobation, you cannot eat your cake and have it. You cannot blow hot and cold at the same time. You cannot sign give assent to the Electoral Act and at the same time give instruction to the lawmakers to delete a particular section, and when they didn't do that, you had to go to the Supreme Court to do what they didn't have to do. So the Supreme Court was invariably saying that was a political question. If you had a problem with the law, approach the National Assembly and not the Supreme Court. And the Supreme Court, it was quite easy for it to just dismiss it. And because of the personalities involved, the Supreme Court would have deprecated the behavior of having to abuse the process of court in the manner which the President and the Attorney General did.
Let's bring in Tobi Soniyi, judiciary correspondent here at Arise News. Really, how significant is this ruling by the Supreme Court? And why does the issue of jurisdiction and local standard continue to rear its head? The appeal court that set aside the ruling of the Abia High Court had pointed out the issue of jurisdiction and local standard by the person who brought the case to the court. That is rearing its head again in this instance. What do you make of all of this, and how significant is this ruling?
Yeah, thank you, Ngozi. I think for once, those who are handling the case have not really done the proper thing, really. Let me start by going first to the case in Abia that the Court of Appeal said the lawyer who filed the case has no business. The plaintiff has no business, he has no interest, he has no locus. I don't know how the point they are trying to make is that you must have a vested interest, you must have something, injury that you suffer before you can invoke the jurisdiction of the court. In this case too, in the Supreme Court, I don't think it's proper for the Attorney General to have used the name of the President, though I like to differ slightly with my learned colleague. I think the Attorney General, as the Chief Legal Officer of the country, has a right in law to challenge whether a law is validly made or not. But the addition of, by adding the President's name, to me, I think it went too far. He will have been able to go on his own as the law officer to say, look, my Lord, I have problem with this act. I believe it violates some section there, violates provision of the Constitution, and I want you to make a pronouncement on it. Probably the Supreme Court may have, taken a different approach. But even beyond that, the Attorney General should have just simply approached the Federal High Court and asked for the interpretation of that section vis-a-vis the Constitution. So the issue is that I really don't know why they are bungling the case. It shouldn't have been something so difficult to adjudicate on. If the right procedure is employed, if the right person filed the case, and if the right court, which we call forum, is approached.
Frank Tietie, Toby talks about procedures there, but the justices in delivering their judgments describe this as an abuse of court processes. You mentioned earlier that instead of approaching the Supreme Court, the president should have approached the National Assembly. So break it down for us, because you understand this better. If the president wanted anything changed in the Electoral Act, and in the instance of this Section 84, subsection 12, what should he have done differently?
He should have sponsored an executive bill to the National Assembly for an amendment. It was purely an abuse of the process of court. I think there was an issue being raised there until I see the full judgment about the application of the Supreme Court Additional Jurisdiction Act, in the sense that the Supreme Court can exercise its original jurisdiction when the National Assembly is involved in a case with the president. And so we're not really talking about the decisions that happened when an individual approached the Umuahia Federal High Court, but the Attorney General just joining the president when there was no conflict whatsoever. The National Assembly did not have any conflict, and it wasn't with the president, and it wasn't a matter that had to do with law but politics. And the Supreme Court realized that, and then we run a presidential federalism that operates the principle of separation of powers. Lawmaking is simply the business of the National Assembly, and then implementing such laws made by National Assembly the business of the executive led by the president. Only when there is a conflict as to law, not conflict as to interest of politicians who believe that, would they not have to be punished for being appointed as special advisors and ministers to the extent that they wouldn't be allowed to participate in convention and congresses to be voted for and to vote. So that's their argument. And don't forget the motivation of the Attorney General, who is somebody who had an interest. And some of the reports give it that the Supreme Court wasn't quite happy, and it agreed with the counsel to the National Assembly that they just merely used the name of the president to activate the original jurisdiction of the Supreme Court. And the Supreme Court was said it was wrong. It was an abuse of the process of court. That is, the president had instructed the members of the National Assembly, I have assented to this law, but take note of Section 84.12. I want you, a kind of instruction being given to schoolboys, go and remove it. It's an instruction. And the members of the National Assembly decided not to remove it. And the president, probably not offended by it, instead of sponsoring an executive bill, now decides.
So in that
to
instance, was it not dead on arrival?
Oh yes, that's why it was.
So that's why the president couldn't go back to the National Assembly with. The process you've just talked about, that the president should have gone back to them instead of the Supreme Court. If the intention of the National Assembly was to make sure there was a level playing field in political parties during primaries and conventions and congresses, then the president had no choice. It was a lost battle for him.
Oh yes, but with time and what has just happened in the Congress and the primaries that we have just experienced, it's becoming very, very necessary for the National Assembly to take another look at that law. And they saw that lacuna and swung into action by making a record amendment to the Electoral Act, which didn't see the light of day. And that's quite funny to see that the president that went to court now had the opportunity to actually assent to an amendment before the primaries, didn't do that, so he cared less. So the Attorney General is the person who needs to answer to what is going on now. Perhaps he had interest, but you see, I would understand on the part of those persons who are political appointees, would they have to be punished just because they went to serve? Again, the National Assembly is the National Assembly's business to solve that, to resolve that, and not by approaching the Supreme Court to take a decision that is more political than law in itself.
Tobi, does this raise a fundamental question as to not just the process of lawmaking in Nigeria, but the real motives behind, these laws? Does it raise such questions for you? And I'd also like you to enlighten us on this blue pencil rule. And does it in any way apply to this issue of 84 subsection 12? Should the Supreme Court have taken liberty to actually expunge that, or any of the other courts?
Well, I think there is enough blame to go around. Let me put it that way. First and foremost, the president took his time before he signed the amendment to the Electoral Act. I mean, if the president had been obliged with advice, he didn't need to sign. He ought to have returned that bill to the National Assembly and said, look at Section 84.12. Then they will quickly have done their work and send it back to him, and then he can sign. So it's also, I mean, the point I'm trying to make is that those who are running the country they are not paying due diligence to what they are doing. You know, we waited for 2-3 weeks before the president signed. We want to assume that the president and his aide, retinues of it, are going through, well, they were supposed to have gone through that law section by section to advise the president and say, look, this is another section that we should object to, and send it back. So it showed that clearly there is lack of due process. I mean, they are not quite paying attention to what matters most. The same thing applies to the National Assembly, who they shot themselves in the leg. I don't know why they are so much in a hurry, and that they are targeting some other people, that they also ended up targeting themselves by omitting some vital section that will have helped them too. You know, I mean, that shows to us that, look, the people that govern us, how much attention are they paying to issues that affect us? On the second leg of your question, the point is that issue did not even arise. That issue did not even arise because it was the justice, they didn't have to go back to their chamber to write a judgment. They sat there and took a decision that, look, we are not going to go into the merits of this case. So they've not gone into the merits of the case. It's only if they've gone into the merits of the case that they will determine whether they can use the blue pencil rule or not. But we didn't get there. As we talk today, neither the High Court nor the Court of Appeal and even the Supreme Court have had the opportunity of taking a proper decision on this law. They've also, all of them have rejected it on basis of procedural error. And that is unfortunate for the country.
Absolutely. Frank Tietie, I'm sure you want to weigh in on that. The appeal court had actually said if it had its way, it would have ruled that that particular section 8412 was actually illegal.
Oh, yes, indeed. We are talking about a law that has been validly made by National Assembly and which obviously did not offend the many provisions that decided from Section 1 through Section 65, through all the provisions that affect the qualifications of the persons and of the various elective offices. So the law was validly made by National Assembly, and if those are affected by the law went to court, it would have been a different thing entirely to have it, interpreted. But we're talking about a precedent that I like the way Kayode Ajulo put it before the court when it's argued that it's as if the president came to court against himself. He signed the law and then came to court to say, look, set aside the law that I signed into law. I mean, what kind of thing was that? Yeah. So we shouldn't, that's why the court said it was an abuse of the process of court. It's not good to waste the time of court, especially that of the Supreme Court, when the persons involved know what they are doing, when they know that they are simply fishing for luck in the courts, when they know that it's simply for political gain. They should have just done the right thing at the National Assembly, and the president didn't need to allow the Attorney General to go that far.
All right.
We have to thank you both, Frank Tietie, Arise News analyst and of course a legal practitioner, as well as our judiciary editor, Tobi. Thank you so much for being on the news with us.